Hi, I'm Clint Rey B. Mosqueda. Writ of Habeas Corpus. The writ of Habeas Corpus is defined as a command directed to the person detaining another, requiring him to produce the body of the person detained at a designated time and place, and to show, cause, and to explain the reason for the detention. All cases of illegal confinement and detention which any person is deprived of his liberty or rightful custody of any person is withheld from the person entitled actual violation before writ issues. In cases of illegal confinement or detention, as to the general rule, the release, whether permanent or temporary, of a detained person renders the petition for habeas corpus moot and academic. As to the exception, where there are restraints attached to his release which precludes freedom of action, in which case the court can still inquire into the nature of his involuntary restraint. As for the grounds for relief, we have three grounds. First is the deprivation of any fundamental or constitutional right. Second, lack of jurisdiction of the court to impose the sentence. Third, in cases of excessive penalty. The requisites are that the petitioner has the right to the custody of the minor, that the rightful custody of the minor is being withheld from the petitioner by the respondent, that it is to best interest of the minor concerned to be in the custody of the petitioner and not that of the respondent. Who may grant the writ? First, we have the Supreme Court of any member thereon. Second, we have the Court of Appeals or any member thereof. Third, we have the Regional Trial Court or the RTC or any judge thereof. And lastly, we have the MPC in the absence of RTC judge. In relation to custody of minors, a verified petition may be filed for the rightful custody of a minor by any person claims such right, and it should be filed in the family court of the province or city where the petitioner resides or where the minor may be found. The requisites for application are: the requisites for application for the writ shall be by petition signed and verified either by the party whose relief is intended or by some person on his behalf and shall set forth. Second, we have that the person in whose behalf the application is made is imprisoned or restrained of his liberty. Third, we have the name of the person detaining another. Fourth, we have the place where he is to be imprisoned or restrained if known. And last, we have the cause of his detention. How writ executed and returned. The officer to whom the writ is directed shall convey the person so imprisoned before the court or judge who issued the writ, unless from sickness or infirmity such person cannot without danger be brought to the court. Make the return of the writ together the day and the cause of the restraint. The return shall be signed and sworn to unless the return is made and signed by a sworn public officer in his official capacity. Okay, let us move on to the procedures in granting the writ of habeas corpus. These are the following: verified petition signed by the party for whose relief is intended or by some other person in his behalf. Second, we have the allowance of writ. Third, we have the command officer to produce service of writ by sheriff or other officer. Fourth, we have the return, and last, we have the hearing of return. The court or judge must immediately proceed to hear and examine the return, unless for good cause shown the hearing is adjourned, in which event the court shall make an order for safekeeping of the person in prison. It is considered an evidence if the prisoner is in the custody under a warrant or commitment in pursuance of law or under judicial order. However, it shall only apply if the facts set forth if restraint is by private authority and the party claiming the custody must prove such facts. If the person was lawfully committed and specifically charged with an offense punishable by death, he shall not be released. If the offense is not punishable by death, that he may be recommitted or admitted to bail in the discretion of the court. The court is satisfied that person is unlawfully detained, they shall order for his discharge, and such copy shall furnish the officer detaining another, and if such officer does not desire to appeal within 48 hours upon receipt, the prisoner shall be released. A clerk of court who refuses to issue the writ after its allowance, a person or to whom the writ is directed neglects or refuses upon demand by the prisoner to obey or make return of the same according to the command, or make false return, shall forfeit to the aggrieved party the sum of 1,000 pesos and may also be punished for contempt. Person discharged not again to be imprisoned, a person who is set at liberty upon a writ of habeas corpus shall not again be imprisoned for the same offense unless by the lawful order or process, and a violation of this shall forfeit to the aggrieved party a sum of 1,000 pesos and may also be punished by the court for contempt. The writ of amparo. The writ of amparo is defined as a remedy available to any person whose right to life, liberty, and security is violated or threatened with violation by an unlawful act or omission of a public official or employee or of a private individual or entity. The privilege of the writ of amparo should be distinguished from the actual order called the writ of amparo. The privilege includes availment of the entire procedure outlined in the rule on the writ of amparo. A judgment which simply grants the privilege of the writ cannot be executed. It is a tantamount to a failure of judge to intervene and grant judicial succor to the petitioner. The writ shall cover extra-legal killings and enforce disappearance or threats thereof. It means protection, provides rapid judicial relief, partakes of a summary proceeding that requires only substantial evidence, serves preventive and curative roles in addressing problems of extra-legal killings and enforced disappearances. Extra-legal killings is defined as the killing of a person by government authorities without the sanction of any judicial proceeding or legal process. Those committed without due process of law or without safeguard or judicial proceedings, example, death squads and riding in tandem. The invalid grounds for the writ of amparo are as follows: trespass to property. Second, lack of coercion to accept invitation. Third, we have the mere anticipation of harassment suits and possible violence. Third, amorphous or uncertain grounds. Fifth, the threat has ceased to exist. What rule governs petition for an issuance of a writ of amparo? It is governed by the rule on the writ of amparo, which was approved by the Supreme Court on September 25, 2007. This rule also governs existing cases involving extra-legal killings and enforced disappearances or threats thereof. What is the Supreme Court's basis in issuing the rule? The rule was drafted pursuant to the SC's constitutional power to promulgate rules for the protection and enforcement of constitutional rights. Who may file the writ of amparo? First, we have the immediate family, the spouse, children, parents of aggrieved party, ascendant, descendant, collateral relative of aggrieved party within the fourth civil degree, consanguinity or affinity in default of number 1. Third, we have the concerned citizen, organization, association, and institution. If no known immediate family or relative of a aggrieved party. Note, filing of petition by a aggrieved party suspends the right of all other authorized party. If the party already filed, others are precluded for filing writ on his behalf. Filing of bet by an authorized party in behalf of a aggrieved party suspends the right of all others. Where to file the writ of amparo? File petition on any day and at any time with the regional trial court of the place where the threat, act, or omission was committed or any of its elements occurred. Second, we have the Sandigan Bayan, the Court of Appeals, the Supreme Court, or any justice of such courts. Writ is enforceable anywhere in the Philippines. Where to return the writ if issued by the RTC? Of course, in the RTC, if in the Court of Appeals or the Sandigan Bayan by itself or any justice thereof, Supreme Court by itself or any justice thereof. Only in the Court of Appeals, Sandigan Bayan, and Supreme Court can delegate return of the writ to RTC issuance of the writ. Court, justice, judge immediately order issuance of writ if on its face it's ought to issue. Clerk of court shall issue writ under seal of court. In case of urgent necessity, judge, justice issue under his own hand. The writ must also set a date, time, for summary hearing of bet not later than 7 days of the date of its issuance. Issuance of the writ. Upon filing for the petition, the court, justice, or judge shall immediately order the issuance of the writ, if on its free it ought to issue. The clerk of court shall issue the writ under the seal of the court, or in case of urgent necessity, the justice or the judge may issue the writ under his or her own hand, and may deputize any officer or person to serve it. The writ shall also set the date and time for summary hearing of the petition, which shall not later than 7 days from the date of its issuance. It can be the clerk of court, and in extreme cases of urgency, it is the justice himself or the judge that can issue the writ in his own hand. The writ must contain the following: date of the hearing, and date must not be later than 7 days for the date of issuance. The following pleadings and motions are prohibited. First, we have the motion to dismiss. Second, motion for extension of time to file opposition, affidavit, position, paper, and other pleadings. Dilatory motion for postponement. Fourth, motion for a bill of particulars. Fifth, counterclaim or cross-claim. Sixth, third-party complaint. 7. Reply. 8. Motion to declare respondent in default. 9. Intervention. 10. Memorandum. 11. Motion for reconsideration of interlocutory orders or interim relief orders. And 12. Petition for certiorari, mandamus, or prohibition against any interlocutory order. In case the respondent fails to file a return, the court, justice, or judge shall proceed to hear the petition ex parte. Summary hearing. The hearing on the petition shall be summary. However, the court, justice, or judge may call for a preliminary conference to simplify the issues and determine the possibility of obtaining stipulations and admissions from the parties. The hearing shall be from day to day until completed and given the same priority as petitions for habeas corpus. Availability of interim reliefs to respondent. Yes, but only the interim reliefs of inspection order and the production order. These interim orders may be issued only after a verified motion is filed by the respondent supported by affidavits or testimonies of witnesses having personal knowledge of the defenses of the respondent, and after due hearing, as to petitioners, he can avail of all interim reliefs. Burden of proof. The parties shall establish their claims by substantial evidence. The respondent, who is a private individual or entity, must prove that ordinary diligence as required by applicable laws, rules, and regulations was observed in the performance of duty. The respondent, who is a public official or employee, must prove the extraordinary diligence as required by applicable laws, rules, and regulations was observed in the performance of duty. Judgment. The court shall render judgment within 10 days from the time the petition is submitted for decision. If the allegations in the petition are proven by substantial evidence, the court shall grant the privilege of the writ and such reliefs as may be proper and appropriate. Otherwise, the privilege shall be denied. The writ of amparo is issued upon the filing of the petition. At the end of the case, once the amparo writ has been issued, return has been made, and hearings have been conducted, the court will now decide whether the quantum of proof required has been met. If it is, then privilege of the writ of amparo is issued. It is the order granting or denying the privilege of the writ of amparo that can be subject to appeal under Rule 45, not the issuance of the writ, because it is merely an interlocutory order. Appeal. Any party may appeal from the final judgment or order to the Supreme Court under Rule 45. The appeal may raise questions of fact or law or both. The period of appeal shall be 5 working days from the date of notice of the adverse judgment. The appeal shall be given the same priority as in habeas corpus. Consolidation. When a criminal action is filed subsequent to the filing of a petition for the writ, the latter shall be consolidated with the criminal action. When a criminal action and a separate civil action are filed subsequent to a petition for a writ of amparo, the latter shall be consolidated with the criminal action. After consolidation, the procedure under this rule shall continue to apply to the disposition of the reliefs in the petition. Right to speedy disposition of cases. Section 16, Article 3 of the 1987 Philippine Constitution states that all persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. The right to speedy disposition of cases is not limited to the accused in criminal proceedings, but extends to all parties in all cases, be it civil or administrative in nature, as well as all proceedings, either judicial or quasi-judicial. While the right to speedy trials is invoked against courts of law, the right to speedy disposition of cases may be invoked before quasi-judicial or administrative tribunals in proceedings that are adversarial and may result in possible criminal liability. According to the landmark case of Coscolluela versus Sandigan Bayan, it was held that criminal case may be dismissed for violation of a person's right to speedy disposition of cases. The right against self-incrimination. Section 16, Article 3 of the 1987 Philippine Constitution states that no person shall be compelled to be a witness against himself. The right against self-incrimination secures to a witness whether she or he is a party or not, the right to refuse to answer any particular incriminating question. It prescribes an option of refusal to answer incriminating questions and not a prohibition of inquiry. The scope and coverage of the right against self-incrimination. The right applies only to a testimonial compulsion and production of documents, papers, and chattels in courts, except when books of account are to be examined in the exercise of the police power and the power of taxation. The right is available in the criminal proceedings, the governmental proceedings, administrative actions wherein the hearing partakes the nature of a criminal proceeding because of the nature of the penalty, legislative investigations, civil actions. The exclusions. An accused may be compelled to be photographed or measured. His garments may be removed and his body may be examined. The court has also declared as constitutional several procedures performed on the accused, such as pregnancy tests for women accused of adultery, expulsion of morphine from one's mouth, and the tracing of one's foot to determine its identity with bloody footprints. The application. The general rule is the privilege is available in any proceedings, even outside the court, for they may eventually lead to a criminal prosecution. Immunity statutes, its nature and purpose. Immunity statutes seek a rational accommodation between the imperatives of an individual's constitutional right against self-incrimination and the legitimate governmental interest in securing testimony by voluntarily offering to give information on the commission of the crime and to testify against the culprits. A person opens himself to investigation and prosecution if he himself had participated in the criminal act. To secure his testimony without exposing him to the risk of prosecution, the law recognizes that the witness can be given immunity from prosecution. In this manner, the state interest is satisfied while respecting the individual's constitutional right against self-incrimination.
Hi, I am Djairah Caceres. Right against involuntary servitude. Section 18, Article 3 of the 1987 Constitution states that no person shall be detained solely by reason of his political beliefs and aspirations. Neither shall involuntary servitude in any form shall exist except as punishment for a crime whereof the party shall have been convicted. Involuntary servitude is defined as condition of enforced and compulsory service induced by means of any scheme, plan, or pattern intended to cause a person to believe that if he or she did not enter into or continue in such condition, he or she or another person would suffer serious harm or other forms of abuse or physical restraint or threat of abuse or harm or coercion, including depriving access to travel documents and withholding salaries, or the abuse, threatened abuse of the legal process. Now, in order for involuntary servitude to be considered, it should consist of the following elements. First, involuntariness, which is a compulsion to act against one's will, and second is servitude, which is some form of labor or service. Now, there are exceptions to the prohibition against involuntary servitude. It could be remembered as panadero na upo, if punishment is for a crime after conviction. Second, in the interest of national defense, all citizens may be compelled by law to render personal, military, or civil service. Third, a return to work order. So it is imperative that the order, in fact, that is not even considered violative of the right. Next is naval enlistment. Another is a worker must obey the order if he wants to retain his work even if his inclination is to strike. Next is the pois comitatus, or the obligation of the individual to assist in the protection of the peace and good order of his community. Another right is the right against excessive fines and cruel punishments. It is stated in Section 19, Paragraph 1 of Article 3 of the 1987 Constitution that excessive fines shall not be imposed, nor cruel, degrading, or inhuman punishment inflicted. Neither shall death penalty be imposed unless for compelling reasons involving heinous crimes, the Congress hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua. Now, cruel punishment involves torture of lingering death, not only severe, harsh, or excessive, but flagrantly and plainly oppressive. Next is wholly or disproportionate to the nature of the offense as to shock the moral sense of the community. The present provision abolishes death penalty, although with a reservation that the Congress can subsequently pass a law imposing it for compelling reasons involving heinous crimes. Now, the import of the grant power to Congress to restore death penalty requires the following. First, that the Congress define or describe what is meant by heinous crimes. Second, that Congress specify and penalize by death only crimes that qualify as heinous crimes in accordance with the definition or description set in the death penalty bill and or designate crimes punishable by reclusion perpetua to death, in which latter case, death can only be imposed upon the attendance of circumstances duly proven in court that characterize the crime to be heinous in accordance with the definition or description set in the death penalty bill. Next, the Congress in enacting this death penalty bill be singularly motivated by compelling reasons involving heinous crimes. Also, proper treatment of persons legally detained or imprisoned. It is stated in Section 19, Paragraph 2 of the Article 3 of 1987 Constitution, which states that the employment of physical, psychological, or degrading punishment against any prisoner or detainee, or the use of substandard or inadequate penal facilities under subhuman conditions shall be dealt with by law. Regardless of being detained or imprisoned, such person shall still be entitled of proper treatment and protection, which includes protection against physical, psychological, or any degrading punishment. Another right is the right against imprisonment for death. Section 20, Article 3 of the 1987 Constitution states that no person shall be imprisoned for debt or non-payment of a poll tax. Debt is defined as any civil obligation arising from a contract. It includes even debts obtained through fraud, since no distinction is made in the Constitution. The definition of poll tax is a specific sum levied upon any person belonging to a certain class without regard to property or occupation. Now, if a person cannot or does not pay his debt, he cannot be imprisoned by reason thereof. Nevertheless, although the debtor cannot be imprisoned, his property may be taken or attached by the court and then sold at the public auction in payment of his debt to the creditor. A person may be imprisoned as a penalty for a crime arising from a contractual debt and imposed in a proper criminal proceeding. Thus, the conversion of a criminal fine into a prison term does not violate the right to a non-imprisonment for debts because, in such case, imprisonment is imposed for a monetary obligation arising from a crime. Next right is the right against double jeopardy. Section 21, Article 3 of the 1987 Constitution states that no person shall be put twice in jeopardy of punishment for the same offense. If an act is punished by a law and in ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. Double jeopardy means that a person is twice put at the risk of conviction for the same or act or offense. The right against double jeopardy means that a person can only be indicted or charged once by a competent court of an offense. Right against double jeopardy has its application on the following circumstances. In administrative cases, it is not applicable. In contempt, it is applicable. Acquittal effectively bars a second prosecution. The termination of jeopardy are as follows. First, by acquittal. Second, by final conviction. Third, by dismissal without express consent of accused. And fourth, by dismissal on the merits. Now, there are two types of double jeopardy. First, if it occurs when a person is put twice in jeopardy of a punishment for the same offense. Second, when an act is punishable by law and an ordinance. However, either of them constitutes as bar to another prosecution for the same act. The requisites of double jeopardy are as follows. First, a first jeopardy attached prior to the second, and second, the first jeopardy has been validly terminated, and third, a second jeopardy is for the same offense as in the first. Now, a first jeopardy attaches only after a valid indictment. Second, before a competent court. Third, after arraignment. Fourth, when a valid plea has been entered. And fifth, when the accused has been acquitted or convicted, or in the case or otherwise terminated without his express consent. There are limitations and exceptions to the rule of double jeopardy. The conviction of the accused shall not be a bar to another prosecution for an offense, which necessarily includes the offense charged in the former complaint or information under the following instances pursuant to Section 7, Rule 117 of the Rules of Court. First, the doctrine of supervening event. The prosecution of another offense is allowable and will not violate the rule on double jeopardy if subsequent development changes the character of the first indictment under which he may have already been charged or convicted. The facts and events transpiring after the judgment and render its execution inequitable would justify the suspension or nullification of such final and executory judgment or order. Second, newly discovered event. The facts constituting to the graver charge became known or were discovered only after filing of the former complaint or information. Third, defective plea bargain. The plea of guilty to the lesser offense was made without the consent of the fiscal and the offended party, except as provided in Section 1 of Rule 160.
Go.
The following are the rules of appeal by prosecution when it is allowed. The general rule is a judgment or acquittal is final and no longer reviewable. It cannot be considered because it places the accused in jeopardy for the same offense. However, there are exceptions. The appeal from acquittal is not double jeopardy. The deprivation of due process, where the prosecution is deprived of a fair opportunity to prosecute and prove its case, provided the judge consider the evidence, even if the appreciation of the evidence leading to the acquittal is erroneous. An appeal or motion for reconsideration by the prosecution will not be allowed. In cases of mistrial, it is also an exception. Another is a grave abuse of discretion, which amounts to lack or excess of jurisdiction. It is to be noted that there is a remedy for the aforementioned cases. Special civil action of certiorari under Rule 65 of the Rules of Court is applicable. Now, there are also other instances when double jeopardy may be invoked. It can be remembered as die to act. First, dismissal based on sufficiency of evidence. Second, dismissal because of denial of accused's right to speedy trial. Third is accused is discharged to be a state witness. It can be noted that there is a waiver of right against double jeopardy. The right against double jeopardy is deemed waived if he appeals his conviction. If the accused had been prosecuted for a higher offense but was convicted for a lower offense, he has technically been acquitted of the higher offense. His appeal would give the court the right to impose a penalty higher than that of the original conviction imposed on him. Now, there is a general rule on the waiver of right against the double jeopardy. Dismissal with consent of accused waives double jeopardy. When the case is dismissed, other than on the merits upon motion of the accused personally or through the counsel, such dismissal is regarded as with express consent of the accused, who is therefore deemed to have waived the right to plead double jeopardy. There is also a provisional dismissal on this matter. A case shall not be provisionally dismissed except with the express consent of the accused with a notice to the offended party as stated in Section 8, Paragraph 1 of Rule 117 of the Rules of Court. The exceptions are as follows. When the dismissal is based on insufficiency of evidence of the prosecution. Second, when the dismissal is based on the denial of his right to a speedy trial. Third, when accused is discharged to be a state witness.
I am Joann Nunez. Right against ex post facto law and bill of attainder. Section 22, Article 3 of 1987 Constitution. Ex post facto law defined an ex post facto law is one which makes criminal an act done before the passage of the law which was innocent when done and punishes such act. Aggravates a crime or makes it greater than it was when committed, changes the punishment and inflicts a greater punishment than the law annexed to the crime when committed, alters the legal rule of evidence and authorizes conviction upon less or different testimony than the law required at the time of the commission of the offense, assuming or regulates civil rights and remedies only, in effect imposes penalty or deprivation of a right for something which when done was lawful, and deprives a person accused of a crime or some lawful protection to which he become entitled, such the protection of former conviction or acquittal or appropriation of amnesty. Bill of attainder. A bill of attainder is a legislative act which inflicts punishment without trial. Its essence is the substitution of a legislative for a judicial determination of guilt. There are three kinds of bill of attainder. The bill of attainder proper, which involves the legislative imposition of death penalty, and the bill of pains and penalties, which involves imposition of lesser penalty. The legislature cannot bypass the judiciary by enacting a law that punishes an act without need of judicial proceedings. The legislative department should be confined to its law-making functions. It cannot encroach the authority of the courts by prescribing a law that directly finds guilt without judicial determination. Citizenship. There are two ways of acquiring citizenship. That is B and N. Number 1 is by birth and number 2 is by naturalization. Natural-born citizens define those citizens of the Philippines from birth without having to perform any act to acquire or perfect the Philippine citizenship. There are three modes by which Philippine citizenship may be reacquired by a former citizen, that is N, R, and V. Number 1, by naturalization, by repatriation, and by direct and act of Congress. Naturalization vis-a-vis repatriation. Naturalization is a mode for both acquisition and reacquisition of Philippine citizenship. As a mode of initially acquiring Philippine citizenship, naturalization is governed by Commonwealth Act No. 473 as amended. On the other hand, naturalization as a mode of reacquiring Philippine citizenship is governed by Commonwealth Act No. 63. Under this law, a former Filipino citizen who wishes to reacquire Philippine citizenship must possess certain qualifications and none of the disqualification mentioned in Section 4 of the Commonwealth Act 473. Repatriation, on the other hand, may be had under various statutes by those who lost their citizenship due to desertion of the armed forces, services in the armed forces of the Allied forces in World War II, service in the armed forces of the United States of any other time, marriage of a Filipino woman to an alien, and political and economic necessity. Main distinction of naturalization vis-a-vis repatriation as two applications. As distinguished from the likely process of naturalization, repatriation simply consists of the taking of an oath of allegiance to the Republic of the Philippines and registering said oath in the local civil register of the place where the person concerned resides or last resided. Effect of repatriation. Repatriation results in the recovery of the original nationality. This means a naturalized Filipino who lost his citizenship will be restored to his prior status as a naturalized Filipino citizen. On the other hand, if he was originally a natural-born citizen before he lost his Philippine citizenship, he will be restored to his former status as a natural-born Filipino. There is a retroactive effect of repatriation. Repatriation granted under TB 725 is to be deemed retroactive to the date of the application. How citizenship may be lost. A Filipino citizen may lose his citizenship in any of the following ways and/or events: by naturalization in foreign country, by express renunciation of citizenship, and by subscribing to an oath of allegiance to support the Constitution or laws of the foreign country. By rendering services to or accepting commission in the armed forces of the foreign country, by having been declared by competent authority, and in the case of a woman upon her marriage to a foreigner, if by virtue of the laws enforcing her husband's country she acquires his nationality. Renunciation of Philippine citizenship. The court held that renunciation needed to lose Philippine citizenship must be expressed. It stands to reason that there can be no such loss of Philippine citizenship when there is no renunciation, either expressed or implied. That's Aznar versus Nicomelec. Natural-born citizens of the Philippines who, after the effectivity of this act, become citizens of a foreign country shall retain their Philippine citizenship upon taking the aforesaid oath. Derivative citizenship under Republic Act 9225. The unmarried child, whether illegitimate or adopted below 18 years of age, of those who reacquire Philippine citizenship upon effectivity of this act shall be deemed citizens of the Philippines. The Bill of 1902, inhabitants of the Philippines who were Spanish subjects on the 11th day of April 1899 and then residing in said islands, and their children born subsequent thereto were conferred the status of a Filipino citizen, that is called versus HRBT. Constitutional basis of citizenship: the Philippine Organic Act of 1902 or Philippine Bill of 1902, the Jones Law of 1916, the 1935 Philippine Constitution, the 1973 Philippine Constitution, and the 1987 Philippine Constitution. Article 4 of the 1935 Constitution provides the following are the citizens of the Philippines: those who are citizens of the Philippine Islands at the time of the adoption of this Constitution, those born in the Philippine Islands of foreign parents who, before the adoption of this Constitution, had been elected to the public office in the Philippine Islands, those whose fathers are citizens of the Philippines, those whose mothers are citizens of the Philippines and, upon reaching the age of majority, elect Philippine citizenship, those who are naturalized in accordance with law. Jus sanguinis vis-a-vis jus soli. Principle of jus sanguinis confers citizenship by virtue of blood relationship. Hence, the child follows the nationality or citizenship of the parents regardless of the place of his or her birth. Such principle can be gleaned in paragraph 3 of section 1 of article 4 of the 1935 Constitution and was subsequently retained under the provision of the 1973 and 1987 Constitution. Principle of jus soli, on the other hand, determines nationality or citizenship on the basis of his place of birth.
Hi, I am Johanna B. Arances. Naturalized citizens. Section 1.4 of Article 4 of the Philippine Constitution, naturalized citizens are those who are naturalized in accordance with the law. To naturalize a foreigner who wanted to become a Filipino citizen, he will undergo a process to become a Filipino citizen. Being a naturalized citizen, the law provides that they are also given the same privilege and rights such as to acquire real property, engage in business, vote during elections, and even run for public office. As citizens of the Philippines, they have to observe loyalty, pay taxes, and obey the laws. There are three modes where an alien may become a Filipino citizen by naturalization. The first one, administrative naturalization. The second one is judicial naturalization. And lastly, legislative naturalization. Administrative naturalization. A naturalization by means of administrative proceedings before the Special Committee on Naturalization pursuant to the Administrative Naturalization Law of 2000. So if a foreigner have been born and resided in the Philippines and he met all the qualifications as provided for in the Administrative Naturalization Law of 2000, then he would be renounced as a naturalized citizen. Judicial naturalization refers to naturalization by means of a court judgment accorded in the revised Naturalization Act. So these aliens desiring to be a Filipino citizen may file their petition for naturalization before the regional trial court who has the sole jurisdiction for the decree of naturalization. Legislative naturalization refers to naturalization by means of a direct act of Congress by enactment of a law. There is a bill passed by the Congress, specifically the Commonwealth Act number 473, that if a foreigner met the qualifications to be naturalized citizen, then he will be admitted into the political community. Qualifications for naturalization. 1. Not less than 21 years of age on the day of the hearing of the petition. 2. Resided in the Philippines for a continuous period of 10 years or more. 3. Of good moral character, believes in the principles underlying the Philippine Constitution, conducts himself in a proper and irreproachable manner during the entire period of his residence towards the government and community. 4. Must own real estate in the Philippines worth 5,000 pesos or more, must have lucrative trade, profession, or lawful occupation. 5. Able to speak and write English or Spanish and any one of the principal Philippine languages. And 6. Enroll his minor children of school age in any of the recognized schools where Philippine history, government, and civic are taught as part of the school curriculum during the entire period of their residence in the Philippines required of. Under Commonwealth Act number 473, Section 3, the 10 years residence requirement imposed by law shall be reduced to only 5 years if the petitioner has the following qualifications. Having honorably held office under the government of the Philippines or under that any of the provinces, cities, municipalities, or political subdivisions thereof, established a new industry or introduced a useful invention in the Philippines, being married to a Filipino woman, engaged as a teacher in the Philippines in a public or recognized private school not established for exclusive instruction of children of a particular nationality or race in any of the branches of education or industry for a period of 2 years or more. Born in the Philippines. On the other hand, for administrative naturalization under Republic Act number 9139, the following are the qualifications. The applicant must be born in the Philippines and a resident since of birth. The applicant must not be less than 18 years of age at the time of filing of his or her petition. The applicant must have received his primary and secondary education in any public school or private educational institution duly recognized by the Department of Education, Culture, and Sports, where Philippine history, government, and civics are taught as part of the school curriculum, and where enrollment is not limited to any race or nationality, provided that should he have minor children of school age, he must have enrolled them in similar schools. The applicant must have a known trade, business, profession, or lawful occupation from which he derives income sufficient for his support, and if he is married and or has dependents, also that of his family, provided, however, that this shall not apply to applicants who are college degree holders but are unable to practice their profession because they are disqualified to do so by reason of their citizenship. The applicant must be able to read, write, and speak Filipino or any of the dialects of the Philippines, and the applicant must have mingled with the Filipinos and showed a sincere desire to learn and embrace the customs, traditions, and ideals of the Filipino people. Who are disqualified to apply for naturalization? Persons opposing to organized government or affiliated with any association or group of persons who uphold and teach doctrines opposing all organized governments. Persons defending or teaching the necessity or has a behavior of violence, personal assault, or assassination for the success and predominance of their ideas. Polygamists or believers in the practice of polygamy. Persons convicted of crimes involving moral turpitude, persons suffering from mental alienation or incurable contagious diseases, persons who, during the period of their residence in the Philippines, have not mingled socially with Filipinos or have not evinced a sincere desire to learn and embrace the customs, traditions, and ideals of the Filipinos. Citizens or subjects of nations with whom the United States and the Philippines are at war during period of such war, or citizens or subjects of a foreign country other than the United States whose laws do not grant Filipinos the right to become naturalized citizens or subjects thereof. Under Section 5 of Commonwealth Act Number 473, 1 year prior to the filing of petition for admission to Philippine citizenship or naturalization, the applicant shall file with the Bureau of Justice a declaration under oath of his intention to become a Filipino citizen. Under Section 6 of Commonwealth Act Number 473, however, the following are exempted from filing of declaration of intention. Persons born in the Philippines and have received those primary and secondary education in public schools or those recognized by the government and not limited to any race or nationality. Those who have resided continuously in the Philippines for 30 years or more before filing their application may be naturalized without having to make a declaration of intention upon complying with the other requirements of this Act. The same rule shall be applied to the widow and minor children of an alien who has declared his intention to become a citizen of the Philippines and dies before he is actually naturalized.
Hello, I am Lyod Lendio. Now, I will discuss to you another form of being a naturalized citizen by acquisition of Philippine citizenship by alien wife married to a Filipino, or otherwise known as derivative naturalization. Pursuant to Section 15 of the Commonwealth Act 473, which states that any woman who is now or may hereafter be married to a citizen of the Philippines and who might herself be lawfully naturalized shall be deemed a citizen of the Philippines. Under derivative naturalization, a foreign woman who are married to a Philippine citizen may be deemed ipso facto a Philippine citizen, provided that the alien woman must follow a certain procedure set by the Bureau of Immigration, which is to file a petition for the cancellation of her alien certificate of registration, alleging, among other things, that she is married to a Filipino citizen and that she is not disqualified pursuant to Section 4 of the Commonwealth Act 473 as amended, which states that number 1, persons opposed to organized government or affiliated with any associations or group of persons who uphold and teach doctrines opposing to all organized governments. Number 2, persons defending or teaching the necessity or propriety of violence, personal assault, or assassination for the success and predominance of their ideas. Number 3, polygamists or believers in the practice of polygamy. Number 4, convicted of crimes involving moral turpitude. Number 5, persons suffering from mental alienation or incurable contagious diseases. Number 6, persons who, during the period of their residence in the Philippines, have not mingled socially with the Filipinos or who have not evinced a sincere desire to learn and embrace the customs, traditions, and ideals of the Filipinos. Number 7, citizens or subjects of nation with whom the United States and the Philippines are at war during the period of such war. And lastly, citizens or subjects of a foreign country other than the United States whose laws do not grant Filipinos the right to become a naturalized citizens or subject thereof. After filing such petition, which should be accompanied or supported by the joint affidavit of the petitioner and her Filipino husband, the Bureau of Immigration conducts an investigation that will grant or denies the petition. Now, let's go to the naturalization or reconciliation of certificate of naturalization. Any person who became a naturalized Filipino can be denaturalized on the following grounds. First, if it is shown that the naturalization certificate was obtained fraudulently or illegally. Second, if the person naturalized shall, within 5 years, next following the issuance of the said naturalization certificate, return to his native country or to some foreign country and establish his permanent residence there, provided that the act of the person naturalized of remaining for more than 1 year in his native country shall be considered as a prima facie evidence of his intention of taking up permanent residence in the same. Third, if the petition was made on an invalid declaration of intention. Fourth, if it is shown that the minor children of the person naturalized failed to graduate from a public or private high school recognized by the Office of the Private Education of the Philippines, where the Philippine history, government, and civics are taught as part of the curriculum, through the fault of their parents, either by neglecting to support them or by transferring them to another school or schools. A certified copy of the decree cancelling the naturalization certificate shall be forwarded by the Clerk of Court to the Department of Interior, now the DILG, and the Bureau of Justice. And lastly, if it shows that the naturalized citizen has allowed himself to be used as a dummy, which is in violation of the constitutional or legal provision requiring Philippine citizenship as a requisite for the exercise, use, or enjoyment of a right, franchise, or privilege. Let's talk about loss and reacquisition of citizenship. Filipino citizenship is not forever. The Constitution states that the Philippine citizenship may be lost or reacquired in the manner provided by law. Let's discuss first loss of citizenship. Loss of citizenship can be voluntary and involuntary. First is voluntary, or also called as expatriation, which means leaving your country and living in a new one. It may be through, number 1, naturalization in another country, number 2, renunciation of citizenship, number 3, subscribing to an oath of allegiance to support the constitution or laws of a foreign country upon attaining 21 years of age or more, and by rendering services to or accepting commission in the armed forces of a foreign country, provided that the rendering of service or the acceptance of such commission in the armed forces of a foreign country and taking of an oath of allegiance thereto with the consent of the Republic of the Philippines, shall not divest a Filipino of his Philippine citizenship if the Republic of the Philippines has a defensive or offensive pact of alliance with the said foreign country, or maintains the armed forces territory with the consent of the Republic of the Philippines. Provided that by rendering such services and commissionship, he or she shall not permitted to participate nor vote in any election of the Republic of the Philippines during the period of his or her service to a foreign country. Next is involuntary loss of citizenship, which may be acquired through, number 1, cancellation of certificate of naturalization by court. Number 2, a deserter of the Philippine Armed Forces in times of war, unless subsequently a plenary pardon or amnesty has been granted, and marriage of a woman to a foreigner, if, by virtue of the laws in force in her husband's country, she acquires his nationality. Next is reacquisition of citizenship. Loss of citizenship may be reacquired. Here are the ways in requiring citizenship pursuant to Commonwealth Act 63 or an act providing for the ways in which Philippine citizenship may be lost or reacquired. First is by naturalization. Naturalization may be applied for by a former Philippine citizen who lost his citizenship under any of the aforesaid ways. Second is by direct act of the Congress. The Congress can also reinstitute, by means of law, a citizenship to those who lost it. And third is by repatriation, or by taking the necessary oath of allegiance to the Republic of the Philippines and then registering the same in the proper civil registry in the Bureau of the Immigration. Take note, the requirement as to qualification and special qualifications prescribed by law for naturalization need not to comply with by a Filipino who once lost his Philippine citizenship. However, the following must be met. First, he must be at least 21 years old and shall reside in the Philippines for at least 6 months. Second, that he must conduct himself in a proper and irreproachable manner during the entire period of his residency. And lastly, that he must subscribe to an oath declaring his intention to renounce his allegiance to a foreign country. Let's talk more about repatriation. There are several laws related to it, and these are, number 1, Commonwealth Act number 63 as amended, or the act providing for the ways in which Philippine citizenship may be lost or reacquired. Number 2, Republic Act 2630, or the act providing for the reacquisition of the Philippine citizenship by persons who lost such citizenship by rendering service to or accepting commission in the armed forces of the United States. He may reacquire the Philippine citizenship by taking an oath of allegiance to the Republic of the Philippines and registering the same with the local civil registry in the place where he resides and last resided in the Philippines. The said oath of allegiance shall contain a renunciation of other citizenship. Number 3, Republic Act 8171, or Act providing for the repatriation of Filipino women who have lost their Philippine citizenship by marriage to aliens and natural-born Filipinos. Number 4, Republic Act 9225, or Citizenship Retention and Reacquisition Act of 2003, which defined dual citizenship and dual allegiance. Take note, repatriation shall be effected by taking the necessary oath of allegiance to the Republic of the Philippines and registration in the proper civil registry and in the Bureau of Immigration. Dual citizenship and dual allegiance. Many of us is confused between these two. Let's discuss these two terms. Dual citizenship is a citizen of two countries at the same time. It is not prohibited by our Constitution because its laws cannot control the laws of other states and generally unintentional. That is, it is only accidentally caused by birth in a foreign state or marriage with a foreigner. And it is only granted to a former Filipinos who lost their citizenship because of naturalization. Dual allegiance, on the other hand, refers to a person simultaneously owes loyalty to two or more states. It is prohibited by our Constitution pursuant to Section 5, Article 4, which states that dual allegiance of a citizen is inimical to national interest and shall be dealt with by law, because it is intentional in the sense that you are voluntarily owing an allegiance to two or more states, which might prejudice the national security of both states. Limitation on dual citizenship. There are several limitations on dual citizenship, one of which is that according to Republic Act 9225, it requires that all those who are seeking elective public offices in the Philippines to execute a personal and sworn renunciation of any and all foreign citizenship to qualify them as candidates in the Philippine jurisdiction. Doctrine of res judicata. These doctrines refers to principle that a cause of action may not be litigated once it has been judged on the merits. Finality is the term which refers to when a court renders a final judgment on the merits. Or in other terms, once the case is resolved by the court, and after 15 days after receiving the judgment, and does not apply for motion or appeal, it cannot be refiled again because of the what we so-called finality of judgment. Generally, this doctrine is unavailable in citizenship proceedings, but it will apply if the following issue of the proceedings arises. Number 1, a person's citizenship must be raised as a material issue in a controversy where the said person is a party. Number 2, the Solicitor General or his authorized representative took active participation in the resolution thereof. And lastly, the finding of citizenship is affirmed by the Supreme Court.
Hi, I'm Joseph Somblingo. Good day. Today, I will tackle about suffrage. Suffrage is a political right conferred process of government which makes the state truly democratic and republican. Suffrage includes election. Election is a process by which the people choose their representative who were entrusted to the exercise of the power of the government. Second is the plebiscite, the process by which the people either ratify or reject an amendment or revisions to the Constitution. Third is the referendum, refers to process by which the people ratify or reject a law or part thereof referred or submitted to them by the national or local law-making body. And fourth is the initiative, the process by which people directly propose or enact laws, that is, the initiative, the law-making process. And lastly, the recall, a mode of removing an incumbent official which is locally elected from office by a vote of the people upon proper registration of a petition signed by the required member of the qualified voter. In suffrage, there are qualifications in order to exercise it. First, you must be a Filipino citizen and at least 18 years of age. You must also be a resident of the Philippines for at least 1 year, or at least a resident of the place where you post to vote for at least 6 months. And to be qualified, you must possess no disqualifications by law. And this is the list of disqualifications by law. First is any person who has been sentenced by final judgment to suffer imprisonment for not less than 1 year, such disability not having been removed by plenary pardon or granted amnesty. Second is any person who has been adjudged by a final judgment by a competent court or tribunal of having committed any crime involving disloyalty to the Constitution, government, such as rebellion, sedition, violation of anti-subversion and firearms law, and any crimes against national security, unless restored to his full civil and political rights in accordance with the law. And as special, it is an insane or incompetent person as declared by competent authority. Before a citizen can exercise his right to vote, he must be undergone a registration. It is a procedural qualifications. A citizen, notwithstanding his qualifications and none of the disqualification, cannot still vote if he is duly registered and his name is not included in the list of voters. So registration is a condition precedent to the exercise of the right to vote. And there is a double registration. When a person who already registered in a place registered anew without filing an application for cancellation of his previous registration, he is considered a double registration. A double registrant is a voter is still qualified to vote. The COMELEC has laid down the rule that the first registration of any voter subsists, and any subsequent registration thereto is void ab initio. RA 9189, otherwise known as the Overseas Absentee Voting Act of 2003, qualifies overseas Filipino to vote for presidential, vice presidential, senatorial, and party list elections. Qualified citizens of the Philippines abroad who fail to register under the RA 9189 may personally apply for registration with the Election Registration Board of the city or municipality where they were domiciled immediately prior to their departure from the Philippines, or with a representative of the Commission of the Philippine Embassies, consulates, and other foreign service establishments that have jurisdiction over locality where they temporarily reside. And here, the list of disqualification from voting under the Absentee Voting Act. First is those who have lost their Filipino citizenship in accordance with the Philippine laws. Second is those who have expressly renounced their Philippine citizenship and who have pledged allegiance to the foreign country. Third is those who have committed and are convicted in a final judgment by a court or tribunal of an offense punishable by imprisonment or not less than 1 year, including those who have committed and been guilty of disloyalty, such disability not having been removed by plenary pardon or amnesty. Note, a person disqualified to vote under this subsection shall automatically acquire the right to vote upon expiration of the 5 years after service of the sentence. An immigrant or a permanent resident who is recognized as such in a host country and any citizen of the Philippines abroad previously declared insane or incompetent by competent authority in the Philippines or abroad as verified by the Philippine embassies, consulates, or foreign service establishments concerned, unless such competent authority subsequently certifies that such person is no longer insane or incompetent. The manner of voting under Absentee Voting Act. First, the overseas absentee voter shall personally accomplish his or her ballot at the embassy, consulate, or other foreign service establishment that has jurisdiction over the country where he or she temporarily reside, or at any polling place designated and accredited by the Commission. The overseas absentee voter may also vote by mail. Voting by mail be allowed in countries that satisfy the following conditions. First, where the mailing system is fairly well developed and secured to prevent the occasion of fraud. Second, where there exists a technically established identification system that would preclude multiply or proxy voting, and where the system of reception and custody of the mailed ballot in the embassies, consulates, and other foreign services establishments concerned are adequate and well secured. The mode of counting and canvassing of votes. The counting and canvassing of votes shall be conducted in the country where the votes were actually cast. The COMELEC shall ensure that the start of counting in all polling places abroad shall be synchronized with the start of counting here in the Philippines. Second, the COMELEC shall constitute as many special Board of Election inspectors as may be necessary to conduct and supervise the counting of votes. And immediately upon completion of the counting, the Special Board of Election Inspectors shall transmit via passmail or electronic mail the result to the Commission in Manila and accredited major political parties. And lastly, only ballots cast on or received by the embassies, consulates, or other foreign service establishments before the close of voting on the day of the election shall be included in the counting of votes. Those received afterwards shall not be counted. the system of continuing registration. A system where the application of registration of voters shall be conducted daily in the office hours of the election officer during regular office hour, provided that no registration shall be conducted during the period of 120 days before the regular election and 90 days before special election. The right to vote of disabled and illiterate. In case of illiterate and disabled voters, affidavit may be prepared by any relatives within the court received with degree of consanguinity or affinity, or by any member of the Board of Election Inspectors who shall prepare the affidavit in accordance with the data supplied by the applicant.
Hi, I'm Obeso. Amendment and revision. Article 17 of the 1987 Constitution provides the manner by which the Charter may be amended or revised. So an amendment is an isolated or piecemeal change merely by adding, deleting, or reducing without altering or changing the basic principles involved in the Constitution. A revision, on the other hand, is a revamp or rewriting of the whole instrument, altering the substantial entirety of the Constitution. Revision. So revision consists of two steps, namely proposal and ratification. So the proposal, which may be first, the Congress, upon vote of 3/4 of its members, may form a constituent assembly. Second, the Congress, forming a constitutional convention. And third, through the People's Initiative. Ratification. So the amendments or revisions to the Constitution should be ratified by the majority in a plebiscite, which should be held not earlier than 60 days, nor later than 90 days after the approval of such amendment or revision. Or in case of initiative, after the certification by the Comelec of the sufficiency of the petition. Pursuant to the doctrine of proper submission, it states that the plebiscite may be held on the same day as a regular election, provided that the people are sufficiently informed of the amendments to be voted upon, to conscientiously deliberate thereon, to express their will in a genuine manner. So, initiative. What is an initiative? So, an initiative is the power of the people to propose amendments to the Constitution or to propose and enact legislation through an election called for the purpose. So there are three systems of initiative. First, the initiative on the Constitution. Second, the initiative on statutes. And third, the initiative on local legislation. So initiative on the Constitution refers to a petition proposing amendments to the Constitution. And initiative on statutes refers to a petition to enact a national legislation. Initiative on local legislation refers to a petition proposing to enact regional, provincial, municipal, city, or barangay law, resolutions, or ordinances. So there are two modes of initiative. First, the indirect initiative. So it is an exercise of initiative by the people through a proposition sent to Congress or the local legislative body for action. Second, we have the direct initiative. So the people themselves file a petition with the Comelec and not with Congress. So rule on local initiative. There must be a sufficient number of registered voters in the local government unit concerned to file a petition with the Regional Assembly or legislative body, proposing the adoption, enactment, repeal, or amendment of any law, ordinance, or resolution. The sufficiency of the number of registered voters would depend on the type of local government. So in the autonomous regions, not less than 2,000 registered voters. Provinces and cities, not less than 1,000 registered voters. Municipalities, not less than 100 registered voters. And barangays, not less than 50 registered voters. So if there is a rule on local initiative, there are also limitations. First is the power of local initiative shall not be exercised more than once a year. Second, initiative shall extend only to subjects or matters which are within the legal powers of the local legislative bodies to enact. So third, if any time before the initiative is held, The local legislative body shall adopt in toto the proposition presented. The initiative shall be cancelled. However, those against such may, if they so desire, apply for initiative. Referendum. So what is a referendum? It is the power of the electorate to approve or reject legislation through an election called for that purpose. A referendum may either be, first, referendum on statutes. It refers to a petition to approve or reject a law or part thereof passed by the Congress. Second, referendum on local law. It refers to a petition to approve or reject law, resolution, or ordinances enacted by regional assemblies and local legislative bodies. Prohibited subjects on initiative and referendum. First, petition embracing more than one subject shall be submitted to the electorate. Second, statutes involving emergency measures, the enactment of which is specifically vested in the Congress by the Constitution, cannot be subject to referendum until 90 days after their effectivity. There are two tests to determine whether amendment or revision. First, the quantitative test. So whether the proposed change is so extensive in its provisions as to change directly the substantial entirety of the Constitution by the deletion or alteration of the numerous existing provisions. In this kind of test, one examines only the number of provisions affected and does not consider the degree of the change. Second, the qualitative test. So whether the change will accomplish such far-reaching changes in the nature of our basic governmental plan as to amount to a revision.